I'm Ricky LeBlanc. I'm the managing attorney at Sokolove Law. In that role, I oversee our entire legal practice and spend a significant amount of my time concentrating on our asbestos practice, meaning representation of those folks with mesothelioma, lung cancer, or other asbestos-related diseases. Someone with a diagnosis of lung cancer can bring a claim if that lung cancer was based upon their exposure to asbestos. Traditionally, that exposure would occur in the workplace while they were working with products that contained asbestos. The claims are generally not brought against your employer, but against the companies that supplied asbestos-containing products that were used while you were working and constructing whatever product you work for. Generally speaking, the difficult part of a case is determining the cause of the asbestos exposure. We have years of research and file drawers full of evidence that will show us what products contained asbestos. Then we have to look to say, what disease do you have? A person with lung cancer could have been many contributing causes. But the question is, did asbestos contribute? And so once we know you've had exposure to an asbestos product, then we will rely on our medical experts to review medical testing such as x-rays to determine whether or not there's any evidence of asbestos fibers in your lungs or other bodily tissue. If those fibers exist, or you have a disease also known to be caused by asbestos, such as bilateral pleural plaquing, it leans more favorably towards a diagnosis of lung cancer caused by asbestos exposure. Over the past 4+ decades of Sokolove Law being involved in asbestos litigation, we have collected a great deal of information regarding a person's exposure to asbestos and the products that they may have been exposed. There is a warehouse of this evidence. Counsel have shared with one another such evidence. Then it's a matter of just figuring out which one of those products you were exposed to. It could be one, it could be 85 or 100, it could be any number. When you explain what you did for work, we look at it and ask you about products. You'll tell us names of products, and we can tell you whether they had asbestos in them or not. And then we'll have documents beyond whether they have asbestos, but even documents that tell us that the companies knew it contained asbestos and that these responsible companies hid that from you, or at least the danger of asbestos to you. Many people come to Sokolove Law with a diagnosis of lung cancer that they believe was caused by their exposure to asbestos, but feel like they can't make a claim because they were also a smoker. Smoking can cause lung cancer. So can exposure to asbestos. The two agents, tobacco smoke and asbestos, actually operate with a synergistic effect, meaning that your likelihood of developing cancer from just being a smoker, or your likelihood of developing lung cancer because you were exposed to asbestos, is actually multiplied by one another. A claim for lung cancer against the manufacturers that used asbestos in their products can vary widely in their values. While we have many clients who have recovered over $1 million for their lung cancer due to asbestos exposure, the range of those verdicts can be something to $1 million or some percentage lower than that. Over the past 45 years that Sokolove Law has been involved in asbestos litigation, and me personally for over 30 years, many of the companies that we made claims against have filed for bankruptcy as a result of those claims. Fortunately, in many instances, those companies were required by the bankruptcy court to establish trust funds to benefit anyone who develops an asbestos-related disease after the company went bankrupt. There are money set aside, some $30 billion in total have been set aside, and are available for the victims of asbestos. people with lung cancer. And while the company can't afford to pay every person every dollar that they're owed, that's why they went into bankruptcy, they have at least put some money away so that they can pay a percentage of that. And many of our clients qualify for more than one of these trusts. And when you add them all together, it can come to a substantial settlement for our clients. To receive compensation for a lung cancer claim, first step needs to be contact an attorney. Once that occurs, the attorneys here at Sokolove Law and elsewhere can fairly quickly put together your claim and determine who your defendants are. Once that happens, they can file their claims with the various asbestos bankruptcy trusts or in a court if that's feasible. When you file with a trust, trusts generally take between 3 and 5 months to make payments. So if you take in some time to review the case and file the case by the lawyer and how long it takes for the trust to make payments, you're in a 3 to 7 or 8 month period. I think saying 6 to 8 months for an initial payment is probably on average a pretty good number to use. But keep in mind, many trusts take much longer, and so it could be you get some money in 3, 5, 6, 8 months, and you get other money in 8, 9 to a year, and maybe even some other money in 12, 13, 14 months. It's just the nature of the way the trust can pay, partly because they can only pay out so much money every year so that they make sure there's enough money for everyone. Nearly all claims, whether they be asbestos claims or any other type of legal claim, has what we call a statute of limitations. That is that each state has determined how long you have to pursue your claim before you forever lose those rights. State by state varies. Some states it's as short as 1 year. In other states, it's as long as 6 years. There's even a state that it doesn't even begin to run until someone tells you that you were exposed to asbestos. So there's no way for me to tell you how long you have to make a claim, but it's best to talk to an experienced asbestos attorney, like the folks at Sokolove Law, so that they can determine whether you're still within the statute. Whatever you do, don't wait. And even worse than that, don't do nothing. You should do something. And it's never too late to ask a lawyer if you have a claim. They can determine whether it's too late for you to file. A lung cancer lawsuit is difficult for the lawyers. We hope that we put our clients first, that our clients' well-being is the most important thing to us. We try to limit any strenuous activity with regard to the client, which means we don't make you travel to us or travel anywhere for that matter. But when it comes to the lawsuit, we try to do the heavy lifting. You're really there as a historian to explain to us what happened and to tell us what you remember. The rest of it is up to us to put together the pieces and file the claims. Often, I unfortunately, have to speak with folks who've already lost their loved one to lung cancer. The fact that your loved one has passed doesn't mean that justice has also passed. The family or heirs under a will have the right to continue the claim, what we call a wrongful death action. So in most circumstances, you continue the claim just as though your loved one was still alive, and the trust funds or courts will award money just as if they were making the claim themselves. And then that money is distributed based upon a will or upon what's called an intestate statute in each state. It's not uncommon for some people to be exposed to asbestos in what we would call a second-hand nature, meaning they didn't directly work with a product that contained asbestos, but instead their loved one worked with that product. And when they came home, it was on their clothes. Then you, or the person with lung cancer now, actually would clean those clothes, shake them out, and would inhale the asbestos fibers that were on their loved one's clothes even though they themselves, the injured party with lung cancer, never work directly with asbestos. They work with their husband's asbestos or their son's asbestos or their daughter's asbestos, meaning what they brought home with them they work with. And that's called secondhand exposure. When it comes to a lung cancer case or any case that goes to a trust fund, which has been established by the bankruptcy courts, making a claim for secondary exposure can be difficult, if not impossible, under some of the rules. However, we will always look at a claim for secondhand exposure to see if a claim can be made in your instance.